The Second Amendment's right to bear arms is at the heart of American identity, woven into the nation's history and culture for over 2 centuries. This constitutional guarantee has sparked passionate debate, inspiring both fierce defenders and determined critics. Today, it remains one of America's most heated and divisive debates, with citizens and lawmakers deeply split over what the right to bear arms should mean in modern society. For decades, states have relied on a patchwork of permit systems, some with strict requirements, others far more lenient, to decide who can legally carry guns in public spaces. This has led to a complex and often confusing landscape for gun owners and law enforcement alike. But now, the Supreme Court's conservative majority is poised to upend these long-standing systems. Landmark cases are challenging the very foundation of state gun regulations, raising questions about the balance between individual rights and public safety. Gun rights advocates argue that permit requirements infringe on fundamental freedoms, claiming that any restriction undermines the core intent of the Second Amendment. Meanwhile, gun control supporters insist these regulations are vital for public safety, helping to prevent violence and keep dangerous weapons out of the wrong hands. The court's upcoming decisions could force states to rewrite their laws from the ground up, potentially redefining where, when, and how Americans can carry firearms in their daily lives. As the nation waits for these rulings, the central question is no longer just about owning a gun, but about how far that right extends into everyday routines, public spaces, and community life. With high-profile cases like Woolford v. Lopez and Markey v. Massachusetts on the docket, the future of firearm permits and the power of states to regulate them now hangs in the balance. The stakes are high, and the outcome could reshape American gun policy for a generation, setting new precedents that will echo across the country for years to come. The legal chaos began in 2022, when the Supreme Court's Bruen decision rewrote the rules for gun laws. The court tossed out the old balancing test, demanding that modern gun regulations align with the nation's historical traditions from the 18th century. This history and tradition test forced judges to become historians, searching for centuries-old analogs to today's laws. Bruen struck down New York's May-issue permit system, declaring the right to carry extends beyond the home. The aftermath: a flood of lawsuits, conflicting lower court rulings, and states scrambling to rewrite their laws. Now, the Supreme Court faces a wave of new cases, tasked with clarifying the boundaries of its own historic ruling. The next decisions will determine how far the Second Amendment truly reaches. Woolford v. Lopez is the Supreme Court's next big test of the Bruen standard. Hawaii's law, passed after Bruen, bans guns in most public and private spaces unless owners post signs allowing them. Challengers say this makes the right to carry meaningless, confining it to a tiny sliver of space. The Ninth Circuit upheld Hawaii's law, but critics argue it relied on the wrong historical period. The federal government has urged the Supreme Court to intervene, warning of a patchwork of unconstitutional gun-free zones. A ruling against Hawaii could strike down similar laws in other states, dramatically expanding where guns can be carried. The decision, expected by June 2026, could reshape public life in America's largest states. Markey v. Massachusetts tackles a pivotal question: do gun rights extend seamlessly across state lines, or can states set their own boundaries? The case began when a New Hampshire resident challenged Massachusetts' rule that requires non-residents to obtain a separate permit to carry a firearm, even if they're already licensed in their home state. Plaintiffs argue this law violates both the Second and 14th Amendments, comparing it to needing a new free speech permit every time you cross a state border. An idea they say is fundamentally un-American. Massachusetts, however, defends its law as a crucial public safety measure, insisting that local control is necessary to protect its citizens. Critics, meanwhile, argue it's an unconstitutional barrier to a fundamental right. If the Supreme Court agrees to hear the case and rules for the challenger, states could be forced to recognize each other's gun permits, much like how driver's licenses work across state lines, regardless of local differences. Such a decision would create a national standard for concealed carry, undermining stricter state controls and marking a major victory for gun rights advocates who have long pushed for reciprocity. For gun control supporters, it would represent a devastating loss of local authority and the ability to set their own standards for public safety. The debate over permit systems is deeply polarized. Supporters say permits are essential for public safety, allowing background checks to keep guns from dangerous individuals. They argue that regulating firearms in public has deep historical roots and prevents chaos and violence. Opponents see permits as unconstitutional barriers to self-defense, forcing law-abiding citizens to beg for a right they already have. They claim criminals ignore permit laws and that armed citizens deter crime and protect themselves. For gun rights advocates, Bruin was a long overdue correction. For gun control supporters, it ignored a tradition of public safety. The fight over permits is a fight over the very meaning of the Second Amendment. If the Supreme Court strikes down permit systems, states with strict gun laws, like Hawaii, California, and New York, could see their regulations vanish overnight. Decades of local efforts to control who can carry a firearm in public would be swept away in a single decision, leaving state officials scrambling to respond. For millions of residents, the rules about who can carry a gun, and where, would change almost instantly, creating confusion and uncertainty. Law enforcement would face new challenges as firearms become legal in places once off-limits, from parks to shopping centers. Officers would need to quickly adapt to new realities, rethinking how they approach routine patrols and respond to calls in public spaces where more people may be armed. Residents would see more guns in public, changing the social fabric, some feeling safer, others more anxious. Everyday activities like going to the park or shopping could feel different as the visible presence of firearms becomes more common, sparking new debates about safety and personal freedom. Permit reciprocity could make the most permissive states' laws the national standard, eroding local control. States with stricter rules would have little power to enforce their own standards, as permits from other states would have to be recognized everywhere, regardless of local preferences. States would scramble to craft new laws, but their power to regulate guns would be sharply limited. Legislators might look for creative ways to address public safety, but their options would be constrained by the Supreme Court's decision. Gun rights groups would celebrate a national permitless carry standard. Gun control advocates would push for federal action. The ruling would energize both sides, leading to rallies, protests, and renewed calls for legislative change at the national level. The ruling could trigger a new round of legal and political battles, keeping the gun debate at the center of American life. Lawsuits and legislative fights would likely follow, as states and advocacy groups test the limits of the new legal landscape. The future of state gun policy may soon be decided in Washington, not in state capitals. As the nation watches, the Supreme Court's decision could reshape the balance of power between states and the federal government for years to come. As the Supreme Court prepares to rule, the nation watches for clues about the future of gun rights. A narrow decision in Woolford could leave many questions unanswered, while a sweeping one could set a new national standard. The court's choice to hear, or not hear, Marquise will signal its appetite for reshaping permit reciprocity. Lower courts and state legislatures will scramble to interpret and respond to whatever guidance emerges. The justices' reasoning, the scope of their ruling, and their divisions will be closely scrutinized. Whatever the outcome, the debate over guns won't end, but the rules of the game may change dramatically. By summer 2026, the legal landscape for firearm permits could look entirely different. The next chapter in America's gun debate is about to be written.